Fred, one of the other areas that we face in the Presbyterian Church in America, the PCA, is the taking something from the local congregation of the presbytery and to the General Assembly through what is known as complaints and appeals. And those are two different sections of Scripture that, or of the book, that have certain rules that we just need to discuss because a lot of questions about that. And I think if you and I just discussed
when you're talking about complaint, you're not talking about Mrs. Smith at the back of the sanctuary saying to the pastor, I don't like which hymns we sang this week, right?
That's grumbling.
Which also we shouldn't do, right?
That's right. And complaining, right. Yeah. So it's right, as you like to say, I heard you say, that's a small c complaint, not the capital C. Okay. The capital C complaint and the capital A appeal is important. And just to really get this thing confused, just to start with, is that when a complaint, which deals, we'll define it in just a moment, moves to the next court, that is not an appeal.
It's still a complaint. That's right. Even though in, quote, the real world, we talk about appeals to the Supreme Court.
Exactly. So we don't confuse our audience here. A complaint, a capital C complaint, is a judicial document that alleges that a court, and a court can be a session
or a presbytery,
you'll allege they have done something in error. They've taken a decision or an action that you believe is out of order. And so the complaint then says, I believe the court on this state with this action acted out of order, out of compliance either with good procedure or the Book of Church Order or the confession. And these are the reasons why I believe it acted out of order.
And really a complaint, and this is under Book of Church Order, chapter 43, really a complaint is not seeking to grumble about something. It's seeking change for the better of the church. Yeah. So if a session, for example, has taken an action that is out of accord with our Constitution or is unbiblical, I could file a complaint against that action seeking to have it changed. And what I do first is I go to the court that's made that action. I give them a chance to make it right, for example, to change their mind. I say, these are the reasons why I think you made a mistake. Would you please reconsider this and fix it?
Right. And it's important in writing that complaint, you need to frame it as, and this is like in the secular court, would be comparable to a constitutional question that needs to be rectified, as opposed to a criminal matter, which you deal with in an appeal. So here is a matter of procedure, of Constitution, and in the PCA, the Constitution includes the Westminster Confession of Faith, the Catechisms, and the Book of Church Order. Right. And so in some way or other, there's a violation, I believe. I'm alleging that to be the case. So as you say, you write it up, and it has to be specific to time.
Does it need to be like 30 or 40 pages long?
No, it doesn't.
Do I need to hire a lawyer to write this for me?
No, you don't.
Oh, okay.
That's right. But you should get some help from somebody who's been down the pike. Again, in all of these things, we're saying it would help if somebody who's been there can guide you so that you don't, so that you're on point.
So if I know a ruling elder in a different church, or I know a pastor or a missionary or someone who's been involved with some of this, maybe they didn't file a complaint, but they've had to deal with one, it might be helpful to send them a copy of it and say, have I done what I need to do?
Make sure that it's good order. That's what you want. Okay, you have to be a member of that court. So if you're a communicant member of a local church and you know the session has taken this action, you can file a complaint. Or, of course, if you're an elder of that session. Right. So you have to be a member of good order. And it has to be filed within 60 days of that complaint, of the action of that's in the complaint. So if you allege that the session acted on such and such a day, within 60 days, you have to say, I believe you've erred, here's the reason, and here are the reasons why. And then you should also say what you would like the remedy to be.
Right.
Okay.
How this can get fixed.
How we fix it. Right. And so that deals with the complaint. So when it goes to the court that is alleged to have acted in error, so let's say it's happened at the session, you have to file it with the session. If it happened first at presbytery, it has to be filed with the presbytery. By the way, at presbytery, only those who are members of that court.
So teaching elders, pastors in the presbytery, or ruling elder commissioners to the presbytery meeting where that action has been taken.
Exactly. And so those would be the ones who are eligible at the presbytery level. So a communicant member of a local church by himself or herself cannot file a complaint against an action of the presbytery.
Now, it seems to me, if I'm a ruling elder and I'm working a full-time job, maybe I own a business, and I'm volunteering at the church, I'm teaching Sunday school, I'm teaching English as a second language classes, I'm really involved, and someone files a complaint, and they are just a grumbler and a complainer. They don't like anything that goes on in the church. It seems to me that the easiest way for me to deal with this is just to 69 it. Just roll it up in a ball and say, this is a complainer, and toss it in the round file, right? Then I don't even have to worry about wasting my time on this.
No, it's not true. Yeah, that's what you would like to do. Restrain your emotions if you're in that feeling that, because it is a judicial matter and it has to be answered one way or the other. And the only possible two answers is you sustain it, we agree that you did wrong, or you deny it. And hopefully you'll state your reasons, because if you deny it, it may be taken to the next court. And so it'd be nice to have your reasons for why you denied it.
Now, what happens if I haven't seen this video yet and I haven't heard this good advice and we don't deal with this as a court? It's still over with, right?
No.
Oh.
Okay. Okay, BCO 43 says that if a court does not take up the matter, the verb is consider. And it's important because we have judicial case history on this, so let's make sure we understand. It must consider the matter at either a called meeting before the next stated meeting, or definitely by the next stated meeting. Now, consider does not mean answer. It means that a court can say, we need to study this, but you need to acknowledge you've received it, that's consider, and set up steps by which you'll
give a timeline.
Exactly, and then you'll answer it. And now, if that answer keeps going on, then you will have been seen to be deleterious. That's a nice word.
Lazy.
or just not doing what you should do.
Right.
Then the person who has filed a complaint can carry the complaint to the next court. So let's say a session is not doing it, not giving you reasons for it, and it's, they've had time to answer it now. Then you can carry to the presbytery saying that the session has not acted in a timely manner on something.
And so if I'm trying to save myself time, what I end up doing is giving myself more work, because if I don't consider this complaint and I don't want to waste the time listening to this person, all I have to do is then I have to appear at presbytery while presbytery considers the complaint. And by the way, the decision's now taken out of my hands because the presbytery will decide.
Exactly, and I can't speak to it.
And then it's also possible that this complaint, if the presbytery does not decide in favor of the complainant, could be taken up to the General Assembly, which is represented by our standing Judicial Commission, which I sit on. And I would have to go then to the standing Judicial Commission, which only has meetings a couple of times a year. So in order to save myself maybe a week's worth of work, I could buy myself a year's worth of trouble.
Probably more if it's not the right thing. But also one more thing on this is that in filing the complaint and dealing with it, they need to make sure they do give reasons. That's an important factor there, because if you don't, then you don't have the mind of the court. It's just the mind of one individual, or they just deny it without any reasoning. Then it's hard to carry forward. Oh, the other thing is that the original complaint, the one that was filed with whether the session or the presbytery, is the same complaint that goes through the system.
I can't add to it as it goes up.
No, you cannot. You just say, I filed this with the session, they considered it, they answered it, they said they deny it. I'm taking that complaint with a new just cover letter to saying I'm bringing the same complaint, believing that the session erred by not answering the complaint or denying it.
And I think that's important because this was something that we clarified in our Book of Church Order previously. And so really, if both the court and the complainant, if someone wants to carry that complaint up, they really should do exactly what you said, which is to draft a cover letter that says, this complaint was denied on this date by the lower court. We're carrying it forward, and slap it on top of the other complaint. I don't add a bunch of other stuff.
No reasoning.
And by the way, there's this other thing, and I'm angry about this.
And you don't answer if the court should, in denying it, give reasons. You don't answer those reasons at that time. You just carry it forward, and then when it's at the next level court, then the next level court will take care of that, and you'll be able to handle the questions at that point, because most likely they will, at that point, have a hearing before a commission, and you could write a brief and things like that.
And this is, of course, important for ruling elders who may hear complaints, and they may hear one complaint every 10 years. They may not have this very often, and they may think that they just need to decide yes or no. But I think your point about giving reasons is important, because if a session denies a complaint and doesn't give any reasons, doesn't write any kind of a decision, then the higher court won't know why, and they won't be able to rule in that session's favor because they may not know what the issue is and how it was framed.
Exactly, but that's the point I'm making, and so many of them don't, because they don't understand this principle. And so when someone comes to defend what the session did, you say, well, wait a minute, where's that in the record? In other words, now you have paper, and that paper doesn't say the mind of the court was this on that, and here are the reasons.
That's right. Now let me raise another issue that's related to this that everybody gets really excited about, and that's taking minutes. Taking minutes in session meetings, Presbyterian meetings. Most people think that's the most boring thing on the face of the earth. Well, no. The most boring thing is reviewing the minutes. And so we try to keep things as short as possible. We don't put things in our minutes. We don't say the actions we've taken. And that's why it's really important for courts, especially sessions, to record in their minutes that they took this action, that maybe for this reason or this issue has come up. Now, you don't need to list all of the discussion and all of the reasons. That would make minutes, you need a tape recorder to do that. But you need to give some context so that if this action needs to be reviewed either by you 6 months later or by a higher court later, that you know why you actually took the action you did.
Right, and that's exactly right. And so having good minutes, because there is a provision in our Book of Church Orders, chapter 40-4, which says that if the record isn't really clear, but you know we can see through other means that an action was taken, then it can be reconstructed by a higher court based on just that peripheral information.
That's right.
So be careful. So it's better that you, as the court, fill in the blanks and don't try and play smart by half by saying we're going to have minimalist minutes. That's not a wise thing.
Now let's deal quickly with the related confusion of what an appeal is. An appeal is not taking a complaint up higher. It's actually an appeal of a trial of discipline. Yes. And there are certain things that have to happen in order for someone to make an appeal, right?
Right. The first thing is that he has to have gone through a trial. So
I can't just not respond to the session and then say, I disagree that you found me guilty?
Right. No, not if you want to appeal it. You've got to go through the trial. They find you guilty. And you say, I don't believe that they used the proper methods, that there weren't proper witnesses, any number of things. In fact, if you go to chapter 42, which is a chapter on appeals, and you go to paragraph 3, so 42-3, it lists at least six areas. That's not exhaustive, but it covers most everything of the reasons why you can file
errors that could be made.
That's right. Prejudice, manifest error, not giving due deference to the appellant is going through the trial or whatever. Those are things that are listed. So you say, I've been found guilty. I believe that the court erred, and here are the reasons why, based on those 6 or whatever other things like that, and you list them. And by that point, the trial has to have had a transcript, and so the transcript will help you
prove those errors.
Yeah, to show you where those errors are.
And this is important, and I've given this advice to folks. So a lot of times someone will say, the deck is stacked against me. They've already been convinced that I'm guilty. There's no reason for me to even show up. This is a waste of my time. And that's actually the worst thing that you can do. What you need to do is submit to the trial, present all the evidence you can so it gets in the record. And then if you don't think you're going to get a fair trial, which I hope never happens in the PCA, I hope that all of our sessions and all of our presbyteries deal fairly and justly in trials. But even if you think that's not going to happen, you still have to be patient and deal with the process and preserve all your rights and pray to the Lord that a higher court will see the errors in that process.
That's the advice I give as well, Fred, because you want to preserve your rights, you want to exercise them, and if you feel that the court is stacked against you, even if you feel that way, it may be, may not be, we don't know, but just in case, don't give up your right to go through the process. You can make statements of objections, you can ask questions of the court to get them on record of certain things that get into the transcript that then you can use later as part of your appeal, and then the higher court can judge. But by the way, in distinction from the complaint, an appeal is filed by a member who's gone through regular trial. You have 30 days to file appeal, not 60, and it goes immediately to the next higher court. It does not go back to the court that just
immediately go up a level.
Go up one more level, and so forth. And and then that court, next court, will judge whether or not the appeal has veracity and whether it will pass muster and so forth.
Now, this is why it's important to take the other side. If you are a ruling elder sitting on a court, this is why you read your book of church order, you ask for advice from other folks, because if you conduct a trial and if the evidence is such that the defendant is clearly guilty, but you have made an error in the process, that appeal could be upheld and that conviction and censure overturned.
Yes.
It's kind of like what we're used to seeing in the old police shows where someone gets off on a technicality. Well, it's not really a technicality here, because the rules that exist in the book exist to preserve biblical rights for defendants.
That is so absolutely right on. To say that you get off on technicality means the other person hasn't read the book well. No, you're following the law. The law says this, this, and this. And so you present that and argue that and make a good case for it, and then you get annulment or something overturned. And that's not a technicality. Your responsibility, if you're the court that's prosecuting the matter, is to read the law and to make sure that what you're presenting is evidence that will convict a person in a complete way without doing violence to his rights or the rights of the Book of Church Order.
So the advice we've been giving throughout these series of videos stands. Take some time to read the book.
Yes.
Get help.
That's right.
I think one of the most dangerous sentences I've ever heard uttered by elders is, "We can handle this by ourselves."
Oh, my, is that true? And the other thing is, when everything else fails, read the instruction manual.